Good morning. Okay. So we have started with what? Article 32. Okay. So we have begin with the idea of fundamental rights. Okay. In fundamental rights concept, we have discussed few important articles. Almost most of the articles we have covered. Okay. That is from Article 12 to Article 31. Okay. What is 12? Definition of state. What is 13? Definition of law. 14? Equality before law and equal protection of law. 15? No discrimination on the basis of caste, race, region, religion and gender. Very good. 16? Equal opportunity in matters of public employment. Very good. Article 17, abolition of untouchability. Article 18, abolition of titles except military and academic. They are permitted, remaining titles are rejected. 19, freedoms. 20, protection in case of offences. 21, right to life. 21A, free and compulsory education. Very good. 22, preventive detention. 23, prohibition of human trafficking. 24, prohibition of child labor. Very good. 25, freedom to practice and profess any religion of own choice. 26, right to manage religious affairs. 27, freedom from payment of taxes. 28, ban of religious practice in educational institution. 29, right of minorities. 30, right to establish educational institutions. 31, right to property. Is it there right now? Yes, but in 300A article. It is not currently a part of fundamental rights. So this is what we have discussed in previous few sessions. Can you remember that? Okay. So after that we will have to enter into Article 32, which is the most important article and also the favorite article of Dr. B.R. Ambedkar. Okay. He says that Article 32 is the heart and soul of the Indian Constitution. Ide Bharata Rajyanganiki Hrudayam Mariyu Atma. Okay. So Article 32 is dealing with right to constitutional remedies. Okay. So we will spend some good amount of time in order to understand this. Because the questions are asked in different connotations. Ante veru-veruga mimmalni questions adugutunnaru, again and again you people are getting confused in this particular part. Okay. So right to constitutional remedies. Okay. What do you mean by remedy here? Remedy means it is a kind of a treatment. Yes or no? A remedy means with which a shortcut you will be eliminating something. You will be protecting something. And the fundamental rights, as I have said earlier also, they are all those rights which can be protected, guaranteed, enforced by the Supreme Court itself. Each and every fundamental right in our country are seen protected. If any of the fundamental right of mine is getting violated, దీంట్లో ఏ ఒక్క fundamental right violation అయినా కూడా I can directly go to Supreme Court. I can directly also go to High Court as well. Meaning, under Article 32, the Honorable Supreme Court will be protecting our fundamental right, while under Article 226, the Honorable High Court will be protecting our fundamental rights. So how to protect the fundamental rights? They can protect by an order, they can protect by the law, they can protect by the act. But here, according to the British law, what we have borrowed, in fact the whole of the constitution we have borrowed from British, but other sources are also there. From the Britain law, we have borrowed an idea of written order. What did I say? Written order. And those written orders within our Indian constitution, Dr. Ambedkar have written in the form of writs. Writs are nothing but written orders. That's been borrowed from British. Ekkada తీసుకున్న వాటిని బ్రిటన్ నుండి గ్రహించడం జరిగింది. But the writs which are seen mentioned within our constitution, within our fundamental rights, though are taken from Britain, their origin is from Britain, but their language is not English. Their language is Latin. ఏ భాషలోనే అవి లాటిన్ భాషలో. We have different types of writs mentioned under Article 32, that is habeas corpus, mandamus, certiorari, covenanto and prohibition. They're all different types of writ. Let's understand, don't worry. Each and every writ we'll have to take up and we'll have to simplify them. Since I said they are all the Latin languages, first of all we'll go for a translation. Yes or no? We'll translate them to Urdu. Okay. So I will translate them to English first, not Urdu. Andariki ardham kaadu Urdu. Okay, naake ardham kaadu. So habeas corpus. Next is mandamus. Then comes certiorari. Then is quo warranto. Then is prohibition. Okay, jagrata. Whenever we speak about the idea of habeas corpus, okay, habeas corpus here means, the literal meaning in English is, it is a writ issued for to present the body of. What I said here, to present the body of. Okay, listen. Mandamus. It is to ask a public official, government officer, government servant, okay, to perform the duties well. తన యొక్క విధులను సక్రమంగా నిర్వహించమని కోరుతూ జారీ చేసే writ is called mandamus. వినాలా? When we speak about certiorari, the literal meaning of certiorari is to be certified. You'll understand, don't worry. What is that? To be certified. Then comes quo warranto. It means by what authority. What does that mean? By what authority? E adhikaramto. That is called quo warranto. Prohibition. It is to forbid. It is to remove. Now come. Habeas corpus means to have the body of. Mandamus means ask a public official to perform the duty well. Certiorari means to be certified. Quo warranto means by what authority. Then comes prohibition, means to stop, to forbid, to remove something. Listen. First of all, a writ of habeas corpus which you will see again and again in the newspapers. Habeas corpus is issued. It means to have the body of that particular individual who have been illegally detained, illegally arrested. అక్రమంగా ఒక వ్యక్తిని అరెస్ట్ చేసినప్పుడు that particular person will be asked to be presented before the court. And the court may look after the idea whether this person is legally arrested or illegally arrested. What is the cause of his particular arrest? Clear? Also, remember, you will be hearing something like in the court, in movies you will be seeing present a person before the court, there will be two bones. Yes or no? విన్నారా వినలేదా? ఒక వ్యక్తిని కోర్టు ముందు హాజరుపరచాలి. Clear all of you? You would have also heard that any person immediately after getting arrested, within 24 hours he should be presented before the court. Otherwise, his detention, his arrest can't be extended beyond 24 hours. Clear all of you? So immediately after the arrest, the 24 hours the police station will have the authority to arrest you. If beyond 24 hours arrest has to be extended, then it should be by a order of the court. Are you getting the point very clear? 24 గంటలు మించి మిమ్మల్ని జైల్లో పెట్టాలనంటే it is only by the court order. The point should be remembered by every one of you. So the court will call, but the court is not very much interested. Are you getting? It is a rule, it is a procedure established by law, where immediately after the arrest he should be taken to the nearest court. The nearest court can be anything. It may be a district court, it may be a subordinate court, it may be a superior court, it may be a municipal court, it may be a chief judicial magistrate, it may be a high court, it may be Supreme Court as well. But usually we will never take directly to the Supreme Court. Chinna PT cases anni kuda Supreme Court is not going to handle them. Okay. So first very important term is habeas corpus. Means what? To have the body of. Okay. My question. Under the writ of habeas corpus, can the Supreme Court or the High Court ask a dead body to be presented before the court? Yes or no? Under the writ of habeas corpus, remember, the Supreme Court may even ask a dead body to be presented before the court. Because if there is any kind of a murder activity, any serial killing have happened, any assassination have taken place, any kidnap and later a murder have happened, then during investigation, during the post-mortem, clues can go missing. A wrong report can be presented. So the judge can issue a habeas corpus also to conduct a post-mortem in front of him. That is a special power undertaken under the writ of habeas corpus. But also remember, the writ of habeas corpus can't be issued against that person who is legally arrested, whose arrest is legal. Are you getting the point very clear? If habeas corpus is issued, it means that to prove that the arrest is legal or illegal. Are you getting the point very clear? Then comes our very next term called mandamus. What do you mean mandamus? Mandamus means to ask a public official. For example, you become a bureaucrat very soon. Okay. మీరందరూ కూడా అధికారులు అయిన తర్వాత, if you are becoming a district collector, if you are becoming a IPS or IRS or some other position you get, what is your role? What is your responsibility? To take care of the district, to take care of the department. Clear? In your district, if somebody comes to you and asks a favor, but you are not doing your job in a right manner, you are doing something else. Clear all of you? After you are joined as a district collector, you are doing some external businesses, some private businesses, which is completely illegal. So against a public official, the court can issue a writ that is called mandamus. Simple. But mandamus can't be arrested against a private person, a private individual. The class should begin at 10 o'clock. Why am I coming at 10:30? Mandamus can't be issued against me. Are you getting the point very clear? Suppose this is a government academy. Hyderabad IAS Academy is owned by the state. It's owned by Government of India. Then I can be issued because I become a public official. Are you getting the point very very clear, everyone? Habeas corpus means what? To have the body of. Mandamus meaning is what? To ask a public official perform the duties in a proper manner. Then comes certiorari and prohibition. See, both of the terms we'll have to take together. Okay. You know, our judicial system, Supreme Court will be at the top. Below the Supreme Court we have High Court. Below High Court we have District Court. District Court is also called Sessions Court. Okay, it is also called ADM, Additional District Magistrate. So they are all in the district level. Jilla stylo ee court lo untayi. Dani kinda we will be having two corners. One is called civil cases and the other is called the criminal cases. Under the civil cases, the very first court is called subordinate court, and below that we have something called munsif court. Under criminal cases, the very first court is called CJM, Chief Judicial Magistrate, and below that we have something called Judicial Magistrate. Okay, understand? Whenever we speak about the hierarchy of our judicial system, if a particular case have happened, then directly we cannot go to the Supreme Court. Okay, we should follow a procedure. Clear all of you? Procedure. Meaning is what if suppose a person is being arrested for taking a bribe. Okay, lunch and this తీసుకోవడానికి arrest అయ్యింది. Okay, is it a civil case or a criminal case? It can be a civil case. Okay, then he will be first of all presented before a municipal court. Clear? Then to the other court, then to the other court, then the district court, then high court, then the Supreme Court. Likewise, the hierarchy will be followed. A person cannot directly be taken to the Supreme Court as such, unless and until there is a pill. Pill means public interest litigation. Praja Prayojana Vajyam ananta. Public interest litigation. That is a different scenario altogether, which you will be saying directly we can move to the Supreme Court. Okay, how come? It is through a pill. If any issue have happened in the matter of public interest, then that can be actually taken in the through a pill. We can directly go to the Supreme Court. Otherwise, the Supreme Court cannot take small petty matters into its contact directly. Another thing, remember, whenever we speak about habeas corpus, it is to have the body of, mandamus it is to ask a public official perform the duty, and now comes to other terms called certiorari and covenant. Sorry, certiorari and prohibition. Listen, if at all, if suppose there is a court called district court. Okay, now ఈ జిల్లా కోర్ట్ ఏం చేస్తుందనంటే, this district court have issued to a particular person, let's say a death penalty. Okay, death penalty is issued అంటే మరణ శిక్ష విధించింది ఒక జిల్లా కోర్టు ఒక వ్యక్తికి. If this person think he may accept the death penalty, but he is having another option also to go to High Court. Yes or no? He may reduce the sentence, reduce the verdict. తనకు వచ్చినటువంటి శిక్షను తగ్గించుకునేటటువంటి ఒక అధికారం కూడా ఆయనకు ఉన్నది. Yes or no? If he go to High Court, then the High Court may say, if that not death penalty, he may be given life imprisonment. జీవిత కాలం కారాగార శిక్ష. Okay, life imprisonment. He still wants some other favorable justice, then he may go to Supreme Court. Okay, and the Supreme Court may say not life imprisonment, he will be given 10 years of imprisonment. Okay, 10 సంవత్సరాల జైలు శిక్ష ఇవ్వచ్చు. Later on he will again go to Supreme Court only. Supreme Court లో కూడా తనకి న్యాయం లభించకపోతే he may again appeal in the Supreme Court itself. Likewise, the hierarchy will follow. Just understand. If suppose district court is not at all having the authority to issue a death penalty, suppose if district court is not having the authority to deal with a certain cases, then still the district court is exceeding its power, exceeding its jurisdiction. Yes or no? తన దగ్గర ఉన్నటువంటి పరిధిని పెంచుకునేటటువంటి ప్రయత్నం జిల్లా కోర్టు చేస్తుంది. This kind of a case, this kind of a verdict should be actually given by Supreme Court. But district court have acted like a highest court, exceeding its jurisdiction. Then the Supreme Court may issue a writ. The writ is called prohibition. What I said? Prohibition. When a district court will be given a writ of prohibition, prohibition is a writ. given by higher court to the lower court. పై న్యాయస్థానాలు కింద న్యాయస్థానాలకు ఇస్తాయి. అదేంటంటే the higher court will ask the lower court, please be in your limit. You should not cross your limit. You should not cross your proceedings. You should not cross your jurisdiction. మీ అధికార పరిధిని ఎప్పుడు కూడా మీరు దాటకూడదు. That is the writ called prohibition. Prohibition means to remove. To remove what? To remove the jurisdiction. Getting the point very clear. Then comes another important term called certiorari. Certiorari is also same. Are you getting the point? Certiorari is also the same.